Welcome to the Environmental Law Institute and the fourth seminar in our summer school series. This one is on clean water. It has been made possible by our members and co-sponsorship from the DC Bar's Environment, Energy, and Natural Resources section. I'd like to thank our faculty for taking time to prepare materials, which are available on ELI's website, and to teach for us today. Today we are joined by Erin Flannery Keith, who focuses on the legal issues associated with EPA's oversight of authorized state national pollutant discharge elimination system, NIPD's programs, and the Office of Wastewater Management's Water Permits Division. Her remarks in this course do not represent the position of the U.S. EPA or the U.S. government. We're also joined by Kirsten Nathanson, who is a partner in Crowell Mooring's Environment, Energy, and Natural Resources Group, and she focuses on environmental litigation, enforcement, defense, risk assessment, and regulatory counseling under the major federal environmental and public land statute. Their full bios are available online.
Thanks so much, Chandra. Kirsten and I are thrilled to be here, and we think this is a great series for you to learn more about the fundamentals of environmental law. We thought we might just start out quickly telling you a little bit about who we are and how we got to where we are. I have been at EPA for 4 years, almost 4 years, and I started out as a legal fellow right after law school as an ORISE legal fellow. The Oak Ridge Institute of Science and Education is a fellowship program for new master's, PhD, and JD graduates. And I was placed in the Office of Wetlands, Oceans, and Watersheds at EPA, where I got some experience with rulemaking and seeing how the regulatory administrative process works. And then I transitioned to a full-time permanent attorney position in the Office of Wastewater Management, where, as Chandra said, I work on the NPDES program, and we have state programs around the country that you'll hear a little bit more about later. I studied environmental law at Pace Law School.
Hi everybody, great to be here. Kirsten Nathanson from Crowell Mooring. I've been practicing law for 15 years. Before law school, I came to Washington a little over 20 years ago, and I spent some time on the Hill with Senator Frank Lautenberg, recently passed. And obviously, being a senator from New Jersey, there were a lot of memos and work for him under the environmental laws, and so I focused on environmental law, George Washington Law School, where Ben Grumbles taught me my Clean Water Act course there. Former assistant administrator for water. He was on the Hill at the time I was in law school. I joined Crowell Mooring right out of law school. I grew up there as a lawyer through the ranks and became partner a little over 5 years ago. And I'm thrilled to be here to share this information with you. With my practice, as Chandra mentioned, covers many of the federal statutes. But I have developed, I have a lot of cases and a lot of deep expertise with the Clean Water Act, and I'm thrilled to be here today to share that with you.
Great. So throughout our presentation, you'll see some photos of our favorite bodies of water, because it's important to connect back to what we want to protect. And I think that for me, being an environmental attorney is a calling to protect a resource that I feel very connected to. And so this is a picture from Niantic, Connecticut, and Kirsten also shares an enjoyment of Long Island Sound, so we wanted to start out with that photo. So to focus us a little bit, here's a map of all the impaired waters in the United States. And part of the Clean Water Act, Section 303D, calls for a list of waters throughout the country that are not meeting water quality standards. And that basically means in simple terms, there's too much of a pollutant in these waters to support the uses for which people want to use them. Perhaps some common uses include swimming or boating, and where you're going to be in physical contact with the water all the time, you might immerse your face in it, versus whether you might get splashed by a paddle. Other uses include industrial uses, drinking water sources. So this map shows that there are many areas of the country that have too much of a pollutant, and common impairments include nutrients such as phosphorus or nitrogen, different chemicals, perhaps legacy pollutants like PCBs that are very hard to remove. Not enough dissolved oxygen to support fish and wildlife habitat or propagation, but maybe too much sediment. So water pollution is a significant problem across the country, and there are a lot of sources of water pollution. Here you see some pictures of the big ones. We often think of pollutants coming out of pipes, so we have some industrial pipes and some stormwater pipes. We also have some spreading of pesticides. The picture in the center and the bottom is a publicly owned treatment works, or a publicly owned sewage treatment system. And mining is an enormous source of water pollution around the country. CAFOs, concentrated animal feeding operations, contribute to water pollution. And in the bottom right, there's a photo of the nutrient pollution in the Chesapeake Bay. Our presentation today will focus on 4 major areas. First, we'll talk about the history of the Clean Water Act. Second, we'll cover the substantive provisions of the Act. We will also discuss some procedural features of the Act, and finish with a discussion of some current issues. I think it's important, before diving into a study of the statute, to think about where clean water law comes from, because we've only had the Clean Water Act since 1972. We also don't have in our Constitution or any other major legislation something specific that says we are entitled to clean water, we are entitled to a clean environment. And so we derive the authority for the Clean Water Act and the other environmental statutes through the Commerce Clause, because the quality of the environment affects the use of interstate commerce. And we have the Clean Water Act, which was promulgated in 1972, and we have according regulations that EPA and the Corps of Engineers, in some cases, we'll talk about that balance in a little bit, have passed by, according to the congressional mandate, to enact each section of the Clean Water Act. Of course, we also have case law, which is very important to how the Clean Water Act is administered and practiced throughout the country. And there are also state laws and regulations that affect how clean water and water pollution are treated in the states. The first major statute that addressed the quality of water was the 1899 Rivers and Harbors Act, and this mainly focused on pollution in waters that obstructed waterways for navigation, and that the Army Corps of Engineers still administers the Rivers and Harbors Act, and you still need authorization from the Army Corps of Engineers under the Rivers and Harbors Act if you're going to conduct any work in navigable waters of the United States. But that focus was on navigation. The first law that focused on, other than navigation, human health, improving the quality of human health, was the 1948 Federal Water Pollution Control Act. There was increasing public concern about the quality of water and the quality of air and the environment in general in the late 60s and early 70s. And this public concern arose when groups of citizens saw that there were environmental problems that no law was quite able to solve. A trespass case wasn't quite enough. A nuisance case wasn't quite enough. And in the late 60s, a group called the Scenic Hudson Preservation Council saw that in Consolidated Edison, the electric company in New York, was proposing to build a electric generating station on top of Storm King Mountain in the Hudson River. And the lower photo is of that, proposed what this plant was going to look like. And so this group got together to try to stop Con Ed from building this hydroelectric dam on top of a mountain that was in a very beautiful scenic area of the Hudson Highlands. And the group was also concerned that there was a proliferation of power plants along this area of the river. And they also noticed that many more power plants meant more fish being entrained and impinged in the intake structures, and there was really no way to stop this. And so they sued, and the Second Circuit held that Scenic Hudson actually had standing to sue based on harm to non-economic interests. They had standing to sue for aesthetic interests. So that was in 1962. In 1969, there was yet another episode of the Cuyahoga River in Cleveland burning, and that's the top picture. And this has happened several times before, but there was so much toxic pollution in the river that it actually set aflame. And when there are rivers burning and mountains being destroyed so that power plants can be built, but their power plants are going to harm water quality, things start to happen. And so in 1972, the big year, Congress amended the Federal Water Pollution Control Act of 1948, and the Clean Water Act was born. And it is now administered by US EPA's Office of Water and parts of it by the Army Corps of Engineers in partnership with the states. And there's certainly a cooperative federalism aspect to the administration of the Clean Water Act. We do want to point out that what the Clean Water Act regulates and what it doesn't. The Clean Water Act regulates water quality. It doesn't directly touch on water quantity or non-point source pollution. Here's a picture of the headwaters of the Colorado River in Rocky Mountain National Park. And you may know about some of the water shortages that occur in the West, and there are water quality implications to it. But the Clean Water Act doesn't directly govern water quantity. And the Clean Water Act also doesn't regulate non-point source pollution. That's sources of pollution from diffuse sources. You can't assign responsibility or liability to any one particular party. You can't give you can't give a permit to a non-point source because you're not exactly sure where all this diffuse flow is coming from. Oops. So the primary goal of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters by mainly eliminating the discharge of pollutants without permits into navigable waters of the United States. So in order to achieve this goal, EPA and the states have several mechanisms. EPA and the states establish water quality standards for various water bodies throughout the states. Remember that first map with all the impaired waters, and remember that impaired means that it's not meeting the uses that people want to use water for. That's part of a water quality standard. That list, that 303D list, lists impaired and threatened waters. EPA and the states also regularly monitor the quality of waters and wetlands around the country. They also develop total maximum daily loads. How much, it's like putting a water body on a diet, basically. How many pollutants can a water body sustain and still be able to fish, swim, recreate, have wildlife and fish living happily in waters that are healthy for them. And those are allocations among all the point sources in a watershed, all the non-point sources, those diffuse sources, and a margin of safety. But of course, there are still going to be industries that need to discharge water. And so how do we make sure that you can still continue commerce and discharge water in a way that's not going to contribute to impairment? And so we do that through permits to point sources. And we include limits that ensure that those sources are going to meet water quality standards. And remember that I said that the Clean Water Act doesn't regulate non-point sources. There are voluntary programs and programs in states that do cover non-point source pollutions. So we'll quickly go through, so you have an idea that the Clean Water Act is evolving and has evolved. The Clean Water Act, there was a settlement agreement that codified the control of toxics in 1977. Rewrote the deadlines for meeting pollution standards, and also gave the popular name Clean Water Act. Because remember, it used to be called the Federal Water Pollution Control Act. In addition to permits and limits and water quality standards and TMDLs, the Clean Water Act also allows for municipalities and governments to obtain funding from the federal government to build treatment plants that will continue to protect the quality of water. Municipal grants and loans. Amendments in 1987 strengthened the enforcement provisions of the Clean Water Act, and also wrote out a little bit more about how non-point sources can be controlled, and allowed funding to go to states to enact those programs. And Occasionally there have been amendments to the Clean Water Act to specifically focus on funding or regulation for specific geographical areas of interest.
Okay, thanks, Erin. Okay, I'm going to talk for a little while here about some of the core provisions of the Act, really where the rubber meets the road, the real meat of the command and control statute that the Clean Water Act is. This is a command and control statute similar to the Clean Air Act and other of our environmental laws. And if you'll notice, if you've already, I don't know if you've already had the Clean Air Act course. Okay, so you'll find a lot of similarity in structure to the Clean Air Act, but there are some important differences as well. So we have the three, the core is the three P's of prohibitions, permits, and penalties. And if you can remember that and keep your structure going that way, you can pretty much, remember the core of the Act going forward. Congress adopted a control strategy based on requiring dischargers to reduce pollution in their effluents in terms of what is going out of the pipe, and using available technology to reduce pollution in their discharges. Whereas prior to the Clean Water Act, the requirements just look to what dischargers can do to reduce pollution based on the levels of water quality in the receiving stream. So this is called an end-of-pipe regulation. It really focuses on what is the makeup of the water discharge that's going out into or water the U.S. The result of this is a really sophisticated and streamlined regulatory and enforcement program. It's 40 years old now. Much of the things I'm going to talk about today have become very standard and routinized, both within EPA and within the regulated community. And the things we'll talk about at the end of the program is actually some of the new cutting-edge issues on how the Act continues to evolve, how it continues to be applied in new ways, and how it still is subject to to debate and change 40 years after its enactment. Also, similar to the Clean Air Act and other environmental statutes, the Clean Water Act does allow for citizen participation, both in rulemaking and the development of the standards and in enforcement and in implementation as well. So so we're talking about a kind of like a three-legged stool that supports implementation and enforcement of the Act. EPA, the states, Erin mentioned that, they're a very important player in the Act, and citizens. So we start with the basic prohibition, which starts with Section 301. Except as in compliance with this section and various other sections of the Act, the discharge of any pollutant by any person shall be unlawful, which means if you are discharging pollutants, and of course all these terms have extensive definitions both from Congress and EPA that we'll talk about, and of course those definitions have been litigated and discussed and debated and further enhanced by EPA. But bottom line, if you are discharging pollutants into the water of the U.S. and you're not in compliance with what I'll describe are water quality-based effluent limitations, technology-based effluent limitations, limitations for toxics, limitations for aquaculture, or your permit, either your 402 or your 404 permit, and all these things we'll discuss. If you're not in compliance with those, your discharge is prohibited. You're in violation of the Act. 301 is really the central provision of the Clean Water Act, and it really goes to the core of the enforcement, and we need to define really now what are point sources, what are pollutants, what is a discharge. So here are the basic elements, as I just mentioned, of the general prohibition. You need an act, a discharge, you need a pollutant, you need a person, you need it from a point source or a discharge of dredge or fill material, you need a water of the United States, and you need to see if you're complying with a permit or not. And one of the questions is, what about mental state? And it's not listed in the statute in terms of the definition of the prohibition, but for civil or criminal liability, what is the required mental state for the Act? So, the easy part for lawyers and for enforcers is that it's a strict liability statute. There's no, civil penalties attach, even if you don't know you're violating the Act. And it's entirely possible, a discharger may know full well that what she's doing may intentionally violate the Act. with either negligently, knowingly, recklessly, or purposefully mental intent. And if you have that, and if the government can prove it, you are criminally liable. Now note, if those are students of criminal liability will note, the Clean Water Act has a negligent level of criminal liability. This is unusual in most federal criminal statutes, but it is a valid level of criminal intent under the Act, that if the government is able to prove that you're intentionally negligent, you can have criminal sanctions in addition to any civil penalties. So it is it's not particularly for civil penalties. You really need to be on your toes, and it does not matter what your state of mind was and whether you know what you're doing is a violation of the Act. So a discharge. This word has been litigated to no end under various point sources, and it means the addition of a pollutant or a combination of pollutants to waters of the U.S. You would think that would be a very straightforward definition, but actually not so much. As it's been interpreted, when you really dig in and try to apply this to particular situations in various industrial sectors, it can get complicated. What is a pollutant? That is defined in the statute, and it basically, I remember Benjamin Grumbles was saying, basically almost anything foreign, is deemed a pollutant. Dirt is included, rock, sand. Obviously sewage, garbage, heat is a pollutant, which is primarily what is discharged from power plants. Larger things, discarded cars, trucks, biological materials, and actually a major debate in recent litigation, maybe within the past several years, was whether pesticides fall within the definition of pollutant. And that was, and actually the Sixth Circuit resolved that question on the issue of point source instead of pollutant, and now probably the newest permit that's come out of EPA is for the application of pesticides. For years, EPA and the regulated community interpreted the Clean Water Act as saying that if you comply with your FIFRA label, another environmental statute, if you comply with your FIFRA label for the pesticide, that is deemed compliance with all other federal environmental laws. Environmental groups challenged that interpretation, and the Sixth Circuit agreed, and now we have a Clean Water Act permit for pesticide application. Obviously by a person, also defined by statute. This is not just individuals. Persons are also corporations, partnerships, municipalities, state or federal agencies, or any agent or employee thereof. And point source. A much debated, and even though no matter how closely defined it is, still debated and discussed in litigation. Also, the statutory definition contains exclusions. So, point source, you must have a discernible, confined, discrete conveyance, including but not limited to pipes, ditch, channel, tunnel, conduits, concentrated animal feeding operations, vessel or other floating craft. There are other examples provided by Congress as well. Agricultural stormwater excluded. That means stormwater that flows off of agricultural fields and other types of agricultural activities. Stormwater discharges from agricultural activity, not from a point source. Irrigation return flows, and obviously everything else that's not in Congress's definition is a non-point source. And we'll talk about this later in current issues. The most recent, I think probably the most recent litigation on the issue of what is a point source has involved silviculture, which is forestry. The Supreme Court just a few months ago resolved a citizen suit dispute over Section 402 permitting for forest roads, for stormwater from forest roads. One of the issues in that case was whether stormwater discharges that's channeled from forest roads, whether that is from a point source, because EPA had issued a regulation back in the 1970s saying that defining what silvicultural point sources are, and defining and then saying that everything else is a silvicultural non-point source, including providing examples such as runoff from forest roads. Citizens challenged that in a citizen suit several decades later. It went all the way up to the Supreme Court. The Supreme Court ruled on other grounds that we can talk about when we get to it, but and the Supreme Court did not reach the point source issue. The Ninth Circuit said that stormwater from forest roads is from a point source. So that's the most probably the most recent litigation on that issue. And actually, as you're learning a new statute and learning the act, sometimes the most useful way to come up to speed, I mean, obviously the textbooks are very helpful and things like this, but to go to the most current cases on the issue and on the statutes are also a good way to really see not only to learn the basics of a statute, but to see how it's being applied and litigated today. And here are some photos, examples of point sources. As I noted, pesticide application, a relatively recent addition to the Clean Water Act permit family. But standard, for years, the start of the act was really focused, like I said, on end of pipe. That was the focus of the agency's regulatory initiatives throughout the 1970s and 80s and onward. And now, now that end of pipe, as I mentioned, has gotten standardized and routinized within the industrial community, they are moving on to other forms of water pollution that may not have been touched on before. So EPA has been looking to how to regulate discharges from concentrated animal feeding operations. I assume this on the bottom, this is a construction site for construction stormwater, and then the ballast water from ships. That's another new permit that has recently been issued by EPA as well. And with that, I will turn it back over to Erin to then talk about probably the most infamous definition within the Act, and probably one of the most litigated, particularly the Supreme Court, waters of the U.S.
Absolutely. Yeah, as Kirsten said, all of those elements of a Clean Water Act violation from the definition have all been litigated, and it continues to be really interesting. So remember that one of the elements to a Clean Water Act violation is it must be into a water of the United States. Now, the EPA and the Corps' regulations have a definition of waters of the United States. And at first glance, it seems pretty self-explanatory, like the elements that you see here. Waters currently used in the past, are susceptible to use in interstate or foreign commerce, subject to the ebb and flow of the tide. Rivers, the ocean near the United States. We can easily think of floating a boat in these waters. Interstate waters, waters that form or share a border between states. All other waters that could affect interstate or foreign commerce. Impoundments of waters of the United States. Just because you build a dam on the river doesn't mean that you've necessarily suddenly made a water not a water of the United States. Tributaries to the four categories that I just talked about. The territorial sea, and wetlands adjacent to the waters that are above it in this definition. And so here's a graphic to try to illustrate what those are. Remember I mentioned Section 10 of the Rivers and Harbors Act before. Those are definitely the waters that have an effect on navigation, and so those are in the middle there. And then Section 404 of the Clean Water Act, and actually the Clean Water Act as a whole, expands that jurisdiction out. So to talk about the wetlands and the tributaries that you may not think of as seeing a boat go down or affecting interstate commerce in a traditional way that you might think about. Those are the waters that those reaches, and so that the Clean Water Act reaches. So over the years, the regulatory definition of waters of the United States has been interpreted to cover a lot of different kinds of surface water. I'll pause for a second and also say that remember when we talked about the waters that the Clean Water Act does not cover, it also does not cover groundwater directly. If there are flows that that may go through groundwater for a bit, but eventually reach water of the United States, those may be included, but the Safe Drinking Water Act covers groundwater. So because I said surface water, I wanted to make that distinction. The surface waters that we commonly think about, rivers and streams, lakes and ponds, wetlands, sloughs, prairie potholes, often found in the high plains of the United States. Intermittent streams that don't flow all the time, but can be generally counted on to flow some of the time. The territorial sea and other waters like that. And I have a picture here of Hanging Lake in Glenwood Springs, Colorado, which is a pretty interesting water because there are mountain rivers that come down into it, and then the lake is actually about 1,000 feet up from the road, which is already at about 7,000 feet of elevation. And then it flows down and through waterfalls and eventually into the Colorado River. But a water of the United States, because it eventually, although there are probably never going to be discharges into it from way up there, it is under Clean Water Act, likely under Clean Water Act jurisdiction. So in the last 12 years or so, the definition of waters of the United States has been litigated in the Supreme Court, and two major decisions affect how we think about Clean Water Act jurisdictional determinations today. The first was Swank versus Army Corps of Engineers in 2001, and the second was Rapanos. So let's take a look at each of these in turn. In Swank, the court held that the Clean Water Act really intended for there to be some connection to navigability, and so waters that were geographically isolated from other traditionally navigable waters. So we're talking about waters where you look at it and it kind of looks like it's hanging out alone by itself in the landscape. There aren't easily found streams that connect it to a traditionally navigable water. So these so-called isolated waters, which again is a term that we have to think about very carefully, because in the hydrological cycle, no water is probably truly ever absolutely isolated from any other waters. But for purposes of determining Clean Water Act jurisdiction, the court had to draw a line somewhere. And so there was a question in this case whether the occasional passage and use of these ponds by migratory birds made it a sufficient enough connection to interstate commerce so as to have Clean Water Act jurisdiction attached, and the court said it did not. And so that sort of tenuous connection to interstate commerce alone does not make a water jurisdictional. And so the practical result of this is that since the Swank decision, the government hasn't asserted Clean Water Act jurisdiction over isolated waters. And the next case that came up was actually consolidated cases that got consolidated under the name Rapanos in 2006. And the question here was whether non-navigable tributaries to their adjacent wetlands were jurisdictional. And this is an interesting case to study. I encourage you to look more into it because it's a case where there was no majority of the court. Justice Scalia was joined by a plurality of judges. There was a 4-1-4 split in the court, and they held that the water is jurisdictional if it's relatively permanent, or if it's a seasonal river, or if there's a surface connection to such waters, and whether that flow is relatively permanent. Justice Kennedy posited that instead of looking for something that's relatively permanent, is there a significant nexus to a traditionally navigable water? So in that analysis, someone who is looking to determine whether Clean Water Act jurisdiction might attach would look for the chemical, physical, hydrological connections between a wetland and traditionally navigable water. So there's a form that the Corps of Engineers has that if you are curious as to whether your water where you're thinking of having a project or a discharge, you might need a Clean Water Act permit for that. There's a form that has all the elements of whether or not you might be able to find a significant nexus. So again, I encourage you to look more into that and to stay tuned, because this is an area of much interest, and it's one of the Clean Water Act hot topics. So remember that one of the P's, we had the prohibition that Kirsten talked about. One of the P's is a permit. So there are two different kinds of permits in the Clean Water Act, but essentially a permit is an authorization or license, something that you otherwise wouldn't be able to do if you didn't have a permit. You can drive if you don't have a license. It's not legal for you to drive without a license. So you can discharge without a permit. It's just not legal for you to discharge without a permit. It's issued by the government, and it's revocable if for cause, just like your driver's license. So the two main kinds of permits in the Clean Water Act are Section 402 and Section 404. Section 402 is the National Pollutant Discharge Elimination System, or NPDES. And these permits are issued by EPA, but mostly they're issued by the 46 states and one territory that have been authorized by EPA to issue permits themselves. So if a state is interested in administering their own Clean Water Act program, they can apply to EPA to have that authority, and the regulations of EPA have standards for how one does that. And basically the state must have their own state laws and regulations in place to allow for a permit program at least as stringent as the federal program would be. So in 4 states, Idaho, New Mexico, New Hampshire, and Massachusetts, EPA writes the permits there, also for Indian country and in Washington, D.C., and some other cases around the country. So largely, the states have authority to issue these permits. The other type of Clean Water Act permit is in Section 404, and these are dredge and fill permits that are issued by the Army Corps of Engineers. And I was mentioning before that the Army Corps of Engineers first makes jurisdictional determinations to figure out whether you have a water of the U.S. and whether you need a permit to begin with. And there are nationwide and individual permits available. Nationwide permits consider projects that are going to happen a lot, and they're probably going to have similar impacts. And so it's a way of streamlining the regulatory process for authorizing these sorts of discharges. EPA is also a partner in this process, along with the Army Corps of Engineers, and EPA has the authority to review and object to 404 permits. And I mentioned that Section 402 permits also, and this is where we see the cooperative federalism, and with the 402 permits, one needs to ensure that the public has an adequate opportunity to participate, to comment on a draft permit if it's a discharge that is important to you, whether it's an industry that's important to you or it's in a water body that you care about. States have to public notice their permits and give the public an opportunity to comment, perhaps even holding hearings before making the permit final. And EPA retains oversight. Even though EPA authorizes states to administer these programs, EPA reviews draft permits and objects if a permit is not as stringent as federal law requires. And there's also no bar to federal enforcement. And the EPA can also remove a program for cause, remove a state's program, although that's never happened before. And remember that I said there are 46 states that are authorized, and also the Virgin Islands. So it's, again, the EPA and states have authority to issue NPDES permits. And with the 404 permits, mostly the Army Corps of Engineers, there are 2 states that are authorized to issue 404 permits, but in that case, it's mostly the Army Corps of Engineers.
Just a few comments on what Erin discussed before I move on. On waters of the U.S., I mean, when I was in law school, I still remember Ben Grumbles at that point, this would have been the late 90s, saying every puddle is a water of the U.S. And that was for years, that was the interpretation. And that was kind of how I entered law practice. You kind of had this default view that every puddle was a federally regulated water. And so the Swank and the Swank decision, which eliminated the migratory bird rationale that EPA and the Corps were using to establish federal jurisdiction over those isolated intrastate waters, was really the beginning of what has now turned into over a decade of litigation and debate on what a water of the U.S. is. There's currently a guidance document that's been pending at EPA, and I believe, or at OMB now I feel like for at least several years, where EPA is trying to, redefine and re-clarify the meaning of waters of the U.S. following the Rapanos decision and trying to reconcile the various opinions of the Supreme Court. But that guidance document has not yet emerged, and there's been growing pressure on EPA to do a new rulemaking from Congress and from the regulated community so we can have some clarity on what is a regulated water and what is not, and ensure that they're consistent with Supreme Court precedent and with the Interstate Commerce Clause. So we'll see how that continues to develop, but it's very much still in play and very much an evolving topic of discussion. Now, enforcement, the last P, penalties. Obviously, our environmental laws have their teeth through their federal enforcement authorities. EPA has wide enforcement discretion on how to enforce the act. They can do so administratively. Administrative penalties, that means that's an enforcement action within EPA. So, I will have clients who will receive from EPA an administrative compliance order from an EPA region or a complaint for an administrative action demanding an administrative level penalty. Usually these are, actually I've never been within EPA, so I don't know the precise decision making they go through in terms of whether they deem something a Class 1 or Class 2 penalty. But generally from my chair, I've seen it, the class depends on how EPA deems the severity of the discharge and various other factors they look to in terms of the cooperativeness, of the defendant, of the ability and the attitude in terms of responding to the violation and coming into compliance. And then EPA has administrative proceedings that fall from those penalties. If there is a dispute, that would go to an administrative hearing within EPA, and EPA manages those enforcement action on their own. But usually they are what I would deem more smaller scale violations. When EPA, when there are alleged violations that rise to a more serious level, EPA will then involve the Justice Department and will seek to bring actions for Section 309D civil penalties. And as I note, those are, and with inflation, if you look at the statute, you'll say, wait, the statute says 25,000 or whatever it says right now. But there's Federal Register notices that up that number with every so often due to inflation. And so currently, Clean Water Act penalties stand at $37,500 per day per violation, and with a 5-year statute of limitations, that becomes real dollars very quickly for those in violation. Oh, and the Inflation Adjustment Act is noted on the slide as well. I'm just seeing if there's anything else I wanted to share on that point. Okay. And I would note the Corps of Engineers is the one with the ability to enforce Section 404, as Erin noted. We have 402 permits, which are issued by EPA, 404 permits issued by the Corps. The Corps of Engineers can pursue penalties under 404. Now, so even though I said there was just 3 Ps and that's all you need to know, now we're going to talk about more details of permits, and we'll call the 4 Rs of NPDES permits. The NPDES permits are made up of restrictions, reporting requirements, reopeners, and then the revocability provisions. And again, the heart of the permit will be the restrictions on the discharges. That is where, again, as I said before, this is really where the rubber meets the road. When you go to someone and they say, I think we have a Clean Water Act problem, the first thing I say is, show me your permit, and then show me your records of discharge. There are 2 ways. EPA there's a 2-part approach in how EPA under the statute develops the restrictions on the discharges. And those restrictions have another term that we're going to develop called effluent limitations. That's the term of art for the restrictions that are built into permits. So Part 1, technology-based standards. All dischargers, they're required to meet treatment levels based on EPA's assessment of the capabilities of treatment technologies that are both technologically and economically achievable in the discharger's particular industry. This technology-based treatment level is considered to be the baseline for dischargers. So everybody will have a technology-based standard. Over the past several decades, EPA has been promulgating industry by industry what are called effluent limitation guidelines, ELGs. So power plants have an ELG. Coal mines have an ELG. Name your industry, it will have an ELG. If it does not have an ELG yet, then it is up to the permit writer's best professional judgment to figure out the technology standard for that permit. And again, this will be the baseline standard and the starting point for NPDES permits. I would note there was a Supreme Court case on this issue back in 2009 called Entergy, the Riverkeeper from 2009, where the Supreme Court concluded, because the statute was silent on this point, and as you may know from the Clean Air Act, when setting ambient air quality standards, EPA is prohibited from looking at cost-benefit analysis for air. For water, and the Supreme Court held in Entergy that EPA can include cost-benefit analysis in establishing technology-based requirements for cooling water intake structures. Now that case involved 316B of the Act, which is a section of the Act that just focuses on cooling water intake structures. But it was a Supreme Court decision of recent note that addressed the cost-benefit analysis issue with respect to technology-based standards. Now there's a whole alphabet soup of acronyms that flow from the technology-based standard, as you also may have learned in your Clean Water Act course. I already mentioned best professional judgment. There's the best practicable control technology currently available, called BPT. There's the best conventional pollutant control technology, BCT. That's also for conventional pollutants. Toxics have their own standard known as BAT. The best available technology, economically achievable, and then new sources. New sources are hit with the most stringent standards. New source performance standards, similar to what you learned about under the Air Act. But all of those, all of those are set forth in EPA regulation pursuant to industry-specific ELGs. And if people are taking notes, those are generally found at 40 CFR Part 400. Throughout Part 400, you'll find the various industry sector technology-based standards. But for most industries, again, this has not been of late, a major debate point within the Act. These ELGs have been long promulgated. These NPDES permits have been coming out on a standard basis for a while, and what's really where the current point of debate is on the second quiver in EPA's arrow in terms of restrictions on discharges, and that's water quality-based limitations. This is the second part of a restriction that can be built into a permit, and these can be more stringent requirements that must be met if they're found to be necessary to achieve the water quality goals of the particular body of water in which that facility is discharging. And so an important thing to also note, though, about water quality standards, this is a state-driven process under the Act. States are the ones who set water quality standards. EPA has a role in terms of reviewing and approving them, and EPA can step in and promulgate its own standards if it feels the state has not done a good enough job. But the starting point, though, for water quality standards is with the states. Now, and then the building blocks for water quality standards are threefold. Every waterway has to have a use. There has to be a designated use. Is this a fishable, swimmable water? Is this an industrial use water? Is this is this just for navigable purposes? So every states first designate uses, and then the states establish what are called criteria to protect the uses. Now, states those criteria can be narrative, which is there shall be no discharge. If the use of the body water, for example, is protection of aquatic life, the state may have a narrative standard. There should be no discharge that shall threaten the aquatic life population. It's usually it's a more subjective standard. States can also issue numeric criteria, and there has been a recent, and this is really where we're seeing a lot more recent activity and pushes for states to move from generic narrative criteria to numeric criteria, and whether that is appropriate for a particular water body, is a case-by-case determination. And then finally, another thing the states need to do is what the short term for it is anti-deg. We call it the anti-degradation policies. Each state must adopt an anti-degradation policy as it's a kind of the third part of your water quality standards. And their policies, they're designed to maintain and protect existing uses by preventing degradation of water quality in waters that meet or exceed existing standards. So basically it's to set to set the floor to make sure that whatever standards waters are currently meeting, and particularly high quality waters, as the states would call them, waters that have not been degraded a great deal by industrial activity over the past several hundred years. For instance, outstanding natural resource waters. The states, the anti-deg policies are in place to make sure that those waters, do not fall below their existing standards. Okay, so how do we implement water quality standards? And Erin touched on this in the beginning. TMDLs, total maximum daily loads. So, for instance, you have a designated use, you have a water quality criteria, and the states have to assess all their waters and come out with a list called the 303D list, a list of the waterways in their states that are not meeting water quality standards. Those are lists of impaired waters. For impaired waters, states need to then establish loads for those waters. So whereas for the individual permitting system, we've talked about kind of what's in the discharge coming out of the pipe. The TMDL concept that the states impose looks at the water body as a whole and says, here's the amount of pollutants X, Y, and Z that this water body can take in on a given day. Your total maximum daily load. And so we can, and it's better to use a concrete example, also one that I'm litigating right now, the Chesapeake Bay TMDL, EPA, and this was a federal TMDL, we'll talk about also in current issues, but EPA stepped in and established a total maximum daily load for the Chesapeake Bay, which is a water body that covers multiple states from New York down to Virginia. Well, it's a watershed that covers from New York to Virginia. The water body of the bay itself covers a subset of those states. But they set a total maximum daily load for the Chesapeake Bay for phosphorus, for nitrogen, and for sediment. And they said, for example, so the total maximum daily load for the bay for sediment is, obviously I don't have the numbers in front of me. It was X number of pounds of nitrogen, phosphorus, and sediment. And that is what the Chesapeake Bay can take on a given year. So what do you do from that point when the state sets a load? If you then you're engaged in industrial activity and you want to set up a factory on a river that is subject to a total maximum daily load, and you go to the state agency to get your permit, the state needs to look at all the other dischargers going into that water and needs to assign you your allocation of that load. They have to slice up the pie of what is being put into that waterway to make sure the TMDL is being met. So if I'm sitting on the James River in Virginia and I'm going to be discharging phosphorus, the state of Virginia has to say, okay, we need to make sure that your phosphorus number is consistent with the allocation we have for the James River for the Chesapeake Bay total maximum daily load. And so it works backwards from the source of the load to the discharger. And so that might result in a permit restriction that might be more stringent than just the technology standard. You might have to do a little extra to meet the load requirements in the river in which you're discharging. And so allocations are the implementation mechanism of TMDLs. And states under the Clean Water Act, and this is where my position might be different from the EPA's. And our position is that states are the ones who implement TMDLs, and states are the ones who set the waste load allocations and the load allocations. And so states set the numbers of, okay, this is how much these various point sources can put into this water body, this is how much can come off the land in a diffuse way from the non-point sources, and this is how we, the state of Virginia, the state of Maryland, this is how we are going to achieve this TMDL. Okay. And we can, I'm sure there might be, and we can circle back and I can answer more detailed questions about that, because I know I remember back when I took a Clean Water Act class, the water quality standard and the TMDL piece is sometimes the hardest part, at least for me, to quantify, because it is kind of backwards from the pipe as opposed to coming from the pipe and what you're putting out. You're instead looking at what should be in the water and tracking back to that to what should then go into your permit to meet that standard in the water. All right, the other critical part of permits, the only way the federal, state agencies and citizens can know if people are complying with their permits and actually discharging what they said they're going to be discharging is to have reporting requirements. You know, if you once you start practicing law, you have a client who gets a Section 308 letter from EPA, which is an information request for your records. I guarantee you, one of the items that EPA is going to ask for are your DMRs, your discharge management reports. These are regular reports that are generated, and now, you know, most companies have very sophisticated environment, health, and safety departments, which have very sophisticated compliance programs and generate these reports on a regular basis. It is the actual listing of what you're discharging, you know, on a daily, hourly, whatever your requirements are in your permit. Your permit will spell out, you need to track this discharge on a daily basis, or you need to report every 6 hours, or you need to do a weekly average or a monthly average. Your permit will spell out what your reporting requirements are. It's critical you follow those. It's critical that you keep accurate records, and it's critical that you not lose any of them. I can't tell you how many enforcement actions there have been over record-keeping violations. People, even regardless of what the discharge actually may have been, if people fudge numbers, you know, take a mulligan on a sampling event, you know, other types of conduct surrounding the record keeping, regardless of whether you actually harm the environment. This is where a lot of enforcement exposure comes, and so it's very important. Also, obviously, all these reports are submitted to the state, usually on a monthly basis, and so this is where citizen groups regularly go into state agencies and review DMRs if they're concerned about a particular discharger. They'll review DMRs, they'll compare them to the permit, all of which will be in the state files, and if the state or the federal government is not taking enforcement action, if citizens identify potential violations, citizens are able to bring enforcement actions on their own. Upset and bypass provisions, those are important within permits, and you have to report. This is particularly important for POTWs, for the municipalities. For instance, I mean, those of us in Washington, D.C., I don't recommend any of you kind of hang out, you know, south of Washington, D.C. along the Potomac River after a rainstorm, because I'll tell you what Blue Plains is doing. They are bypassing, because most municipal wastewater treatment plants in this country cannot handle certain rain events, particularly those in the eastern U.S. that have combined stormwater and wastewater flows. And so permits will have upset and bypass provisions where you can get a pass when there's an extraordinary event where your plant cannot handle all the water coming in, and so POTWs need to let it go and let the Potomac River take it on its way. And so, yes, the duty to provide information and right of entry, I mentioned that. That's Section 308 of the Act. So you know, if you are a point source, if you are subject to the requirements of the Act, EPA always has the ability to show up and inspect and see your records, and has the ability to write to you and say, provide us with your records, and that's part of the Act as well. And sometimes EPA can come in and amend the permit if they believe that additional monitoring or other studies are required based on how your discharge reporting is happening during the term of your permit. I can't remember if we've already mentioned this, and Section 402 permits have a 5-year permit term, and so, you know, you can, as you know, EPA can come in and reopen, or the states, most of the states in this instance, you know, as we'll talk about, can reopen and impose additional requirements on you if your actual discharge isn't quite jiving with what was set forth in your permit when it was developed. So yes, reopen if there's a change in circumstances, if additional information is needed, if your operations have changed, a change in the discharge, if toxic standards change in the regulations during the term of your permit, these are all causes for the state or EPA to come back and amend your permit following issuance. Now, usually, to have a permit revoked is a very serious option. It doesn't. I'm not really aware of it happening all that often. I mean, it really is. It's kind of it's the ultimate hammer EPA has to take your permit away from you. Obviously, most folks in the regulated community who are interested in continuing commerce and producing goods and services for our society want to be in compliance with environmental laws so they can continue to do that and meet that balance. And so it really is. It would be a remarkable fact pattern that would lead to the revoking of a Clean Water Act permit. And finally, I've already, citizen suits, we have touched on this already, but the citizen suit provisions are found in Section 505. It has been, I think, the Clean Water Act may be, I don't think I've done an empirical study on this, but we watch enough of the litigation to know that it's fair to say the majority of environmental citizen suits that are brought tend to be brought under the Clean Water Act. Actually, NEPA might be a close, NEPA might tie for that in this day and age today. But you can, there are several important requirements in Section 505. A citizen group, if they want to bring a citizen suit, need to first provide notice. You have to provide 60 days notice to the potential defendant that you believe they're violating the act. You have to describe the violation with reasonable specificity, and you can't sue until 60 days after you have sent that letter. The purpose is to allow time to cure by the person who you sent the letter to, and also to give the state or federal governments the ability to start enforcement themselves. Because you have to copy both EPA and the state regulators on your notice letter. And because the whole point of the citizen suit provision is not to have an extra layer of enforcement imposed on the regulated community on top of the states and the federal government, but it's meant to be gap filling. It's meant to be, if the state and the federal government is not responding to a problem, citizens are empowered to do that under the act. But the notice is very important, and the other important element here is a diligent prosecution bar. If you file, if you file a complaint or send a letter or file a complaint against one of my clients where we are already engaged in an enforcement action with the state or with EPA, there is no jurisdiction over your citizen suit because the state or the federal government is already engaged in active enforcement, and the act does not kind of allow for that extra layer of citizen suit litigation. But if the state and federal government has not acted and you move forward, it then proceeds in federal court as standard federal civil litigation with discovery, with motion practice, bench trials. You need to prove up your standing. Standing is litigated often. You have to prove, and you also have to prove, one thing that's on here, you have to prove it's a continuing violation. You just can't sue for something that happened in the past where there's not a reasonable likelihood that's going to happen again. If you allege that a plant was having some kind of problem in its discharge, but then the plant cured it, or the plant shut down that part of the plant that was having the problem, or the plant changed its operation, and there's no way that's going to happen again, you don't have jurisdiction because you need to have it's a Supreme Court decision called Gwaltney. You need to have a continuing violation at the time you filed your complaint, and that's another topic of citizen suits that is litigated frequently. And of course, citizen suits also are, the precedent in citizen suits are filled with cases that fight over whether something is a point source, whether something is a discharge, whether something is a continuing violation. All those are, whether the notice is adequate. There's been a fair amount of litigation on whether the notice letter adequately described the violations. There's a host of issues that have come up in precedent that are good to read up on as you're learning the contours of the act. I think, and we'll go to current issues. There we go.
So before we jump into current issues, we got a question from one of our listeners on the telephone that I think pertains exactly to what we were just talking about,
Right.
and I think we may have already answered it. But I think the question came in before we got to it. So the question was, how are violations brought to the attention of regulatory bodies via lawsuit or citizen reporting? So I think Kirsten's description of the submission of discharge monitoring reports and EPA's and the state's ability to inspect facilities and to determine whether there have been excursions from limits, and then also the citizen suit opportunities. And there are, on EPA's website and also on many state websites, accessible opportunities for citizens to engage, and sometimes there's even a button that says something to the effect of find a complaint, have a complaint, and then someone from the state can follow up. So current issues, we are going to talk about several things that have come to the attention of the Supreme Court and other courts in the last 5 years. So we'll first talk about the intersection of 402 and 404 permitting and enforcement compliance orders, logging roads, which Kirsten mentioned before, and also the Chesapeake Bay TMDL, nutrients, numeric and narrative criteria, and how those get into permits, what challenges are there, and also the Clean Water Act and coal, another exciting and very variable topic. So first, let's talk about a case that came to the Supreme Court in 2009, Core Alaska, a mining company, versus the Southeast Alaska Conservation Council, a citizen group. And this went through the district court in Alaska and then the Ninth Circuit. And the problem and the issue here was that the Core Mining Company was proposing to discharge mining slurry into Lower Slate Lake, which is a lake in Tongass National Forest in Alaska. And this mine was a gold and molybdenum mine, and the mining tailings were in a form where there were some solids and some liquids. And the question was, should the Corps of Engineers issue a 404 permit for the discharge of fill material, or should the state of Alaska issue a permit for the discharge of a pollutant pursuant to a 402 permit, discharge a pollutant pursuant to a 402 permit with effluent limitations that Kirsten talked about. So effluent limitations only go into 402 permits. They don't go into 404 permits. And this is also a question of whether this material, this mining slurry material, part liquid, part solid, had the effect of fill, or whether it was a pollutant subject to 402. And the district court found that the grant of a 404 permit was proper, the fill permit. The Ninth Circuit reversed and said, no, there are effluent limitations the EPA has promulgated for the ore mining and dressing industry. There should be a 402 permit that has these effluent limitations in it. And the Supreme Court reversed the Ninth Circuit and held that the Corps properly issued the 404 permit for the discharge of this slurry into Lower Slate Lake. And the court looked to and gave deference to EPA and the Corps' 2002 fill rule, which talks about how slurry and other related mining materials are fill. And then there is also a memo that the court deferred to that described when there are situations like this, if it has the effect of fill, it is properly permitted under 404. So there's the before and after picture of Lower Slate Lake. The top is the before, and then the lake got filled in. So the issues like this come up a lot, where permittees and environmental groups are curious as to which permitting regime applies, because you can, for one discharge, you can only have one or the other. You can either have a 404 permit or a 402 permit. And so perhaps some clarity to that might fix that, but for now we have the structure that the Supreme Court has held in the Core Alaska case. Last year, there was a case that came to the Supreme Court called Sackett versus EPA. And the key points here deal with the debate over the definition of waters of the United States and pre-enforcement review. So remember that we talked about there's ongoing difficulty determining what a water of the United States is, which is navigable or has a significant nexus to a navigable water, and then defining the jurisdictional bounds of the Clean Water Act. And if a wetland area is found to be jurisdictional, then the property can't be filled in without a 404 permit. And the case also addressed the timing about how disputes about this should be addressed. So in this case, there were two plaintiffs, a couple. They filled in an undeveloped lot with land and dirt, and they were preparing to build a house. And in response, EPA issued a compliance order against the Sacketts. This was in Idaho, which stated that the lot was a wetland and it was protected by the Clean Water Act, and that the Sacketts were violating the Clean Water Act because they did not have a Section 404 permit. They failed to obtain a permit before they started filling in the land. And the compliance order ordered the Sacketts to put the land back the way it was, or the EPA threatened to fine them over $30,000 per day until they came back into compliance. So the Sacketts requested a hearing in federal court, and they sought a declaration that the property was not a wetland, it was only intermittently wet, it was not connected to a traditionally navigable water, and the district court granted EPA's motion to dismiss for lack of jurisdiction because the court said that judicial review of the compliance order at that time was improper. So the Sacketts appealed to the Ninth Circuit. And the Ninth Circuit held that the Clean Water Act does preclude review, that before, if you have a compliance order, you can't challenge that until you are sued by EPA. And the court heard the case in January of 2012 and made the decision pretty quickly after that, I think in March, and held that a Clean Water Act administrative compliance order is a final agency action subject to review under the Administrative Procedures Act, and that the Clean Water Act itself does not overcome the presumption of review of a final agency action under the Administrative Procedures Act. But the court didn't reach the jurisdictional question of whether or not the Sacketts' land was subject to Clean Water Act jurisdiction. This, yeah,
Decker.
Yeah, Decker.
You want to do Decker? You can do Decker.
Oh, would you like to do Decker? So this was argued in December. It was a hot big week in the Supreme Court for the Clean Water Act. There was another case heard that week on Los Angeles, on the Los Angeles River, and it was a municipal stormwater case. So 2 days in a row, the Supreme Court got to hear about EPA and the Clean Water Act. And the question here was whether, well, there are a few questions. One of them was whether the citizen suit provision could be used to challenge the validity of a rule that had been promulgated a long time ago, and whether the Ninth Circuit erred in finding that stormwater from logging roads was industrial stormwater subject to Clean Water Act Section 402. And the court held that EPA did not consider, in its sort of two-phased look at stormwater. The first phase was enumerated sources that are related to stormwater related to industrial activities, and the second phase was other kinds of stormwater. EPA didn't say in phase one that logging roads were subject to NPDES permits. So that story continues. If you want to add in some more.
Sure. I mean, I should. And this is full disclosure. I'm outside counsel to the National Alliance of Forest Owners and did an amicus brief in this case. So yes, it's near and dear to my heart. And it's a case that's been going on for quite a while. And just touch on a few things which actually illustrate a lot of the concepts we've already discussed. First of all, this case started out as a citizen suit. It was a citizen suit filed in Oregon, maybe back, I feel like 6-7 years ago now. I lose track of when it actually started. But it was a citizen group that sued both the state of Oregon and various timber landowners, saying that the stormwater that is flowing off of forest roads requires an NPDES permit, and they don't have one, and so they're in violation of the act. There was a regulation EPA promulgated as I noted earlier, several decades ago, that defined that rainwater runoff from forest roads as a silvicultural non-point source. And so the Ninth Circuit, I'll back up, I'm sorry, the district court simply looked at the citizen suit and looked at the regulation and said, there's a regulation that defines this as a non-point source. There's no Clean Water Act violation. There's no case here. We're granting the motion to dismiss. The Ninth Circuit took the opportunity to review the validity of the regulation from several decades ago on whether EPA properly defined the discharges of this type of stormwater as from a non-point source. The Ninth Circuit did a two-part ruling saying, yes, these are point sources, and yes, this is also industrial stormwater regulated under the Phase 1 of the 1987 Stormwater Amendments that Erin mentioned at the beginning of the presentation. The Supreme Court only resolved the second of those questions. The Supreme Court did not touch one way or the other, so they didn't need to decide decide whether the Ninth Circuit was right or not on whether or not these were point sources, because they said this isn't industrial stormwater, and therefore it's not subject to stormwater permitting, and therefore the case was reversed and remanded. But the saga does continue. I think yesterday in the Farm Bill, the House just passed an amendment codifying the regulation from several decades ago, saying that this stormwater does not require Clean Water Act permits, and the litigation also continues. Now that we're on remand to the Ninth Circuit. I would also say one of the more entertaining moments of, I guess for those who are Supreme Court jocks in oral argument, was that the Friday before oral argument, EPA issued a final regulation saying that this stormwater is not subject to the industrial stormwater requirements. And Chief Justice Roberts kind of read the Riot Act to the Solicitor General, saying, you could have given us some notice that you were going to do this before you made us read 800 pages worth of briefs and prepare for this argument. And then there was another round of briefing after oral argument from the United States, the citizen groups, and the forestry defendants to talk about the meaning of EPA's regulation that they issued right before the Supreme Court opinion. So the Supreme Court opinion is actually it's actually a very good discussion of the 1987 Industrial Stormwater Program, and it's a good primer on a lot of those stormwater issues as you're getting grounded in the Act. I'm sorry. So we'll just a few more current issues as we move to, and then we can take questions. As I mentioned when I was talking about water quality standards, numeric and narrative criteria, and also in nutrients, these are all very hot issues right now in a series of various cases, involving EPA, states, the regulated community, and citizen groups. There is a current challenge to the Chesapeake Bay TMDL by a coalition of agricultural and home builder groups, not questioning EPA's ability to issue a TMDL. I think those parties would agree that that's clear in the statute, that EPA has the ability to step in and issue a federal TMDL when the states do not. And I'm counsel of record in this case, so I should disclose that right off the bat. But the issue with the Chesapeake Bay TMDL is that the regulated community's point of view on that is that EPA is dictating implementation. This wasn't just a set of 3 numbers that said, okay, for the Chesapeake Bay, this is how much nitrogen, this is how much phosphorus, and this is how much sediment the Chesapeake Bay can hold. The Chesapeake Bay TMDL then has appendices upon appendices with very detailed allocations to every POTW, to many factories and farms and private residences and home developments from Virginia up to New York. And our contention is that as the individual states who have the authority and the sole authority to implement the Chesapeake Bay TMDL, and EPA defends its position that it had the ability to impose these allocations. So we are waiting for a federal district court decision, and we'll see how that plays out. Numeric nutrient criteria. There has been the Florida Wildlife Federation and other citizen groups. There's been extensive litigation in the state of Florida on whether there should be numeric nutrient criteria for the waters in the state of Florida. As I talked about, you can have narrative criteria or narrative or numeric criteria. And Florida challenged a determination from EPA that numeric criteria are necessary in the state of Florida in order to meet the requirements of the Act for Florida streams. Florida challenged that determination, and it was a very complicated series of litigation. But the bottom line is that Florida's challenge to EPA's determination was rejected. Various other elements of the litigation were upheld in terms of whether the numeric criteria that had been established were appropriate. But Florida and EPA have now, that saga is now ongoing. More new rounds of the numeric criteria are coming out and being commented on, and likely will also be litigated. But the issue of whether criteria to, or how, I'm sorry, whether water quality standards for nutrients, and we're talking about nitrogen and phosphorus, whether those should be in narrative or numeric form, are playing out in multiple jurisdictions. Environmental plaintiffs sent a petition to EPA, and various environmental groups sent a petition to EPA saying there needs to be numeric criteria for nutrients in the entire Mississippi River basin. So that would cover from Louisiana all the way up to the headwaters of the Mississippi River. I think it covers a good portion of the United States. EPA denied their petition that numeric criteria were necessary. The denial of that petition is now being litigated in Louisiana federal court. And then also another recent decision of note, the state of Virginia challenged an EPA TMDL that it imposed on one of Virginia's waterways, where the EPA said the criteria was the flow. They didn't actually have a constituent. They're not a pollutant. They were trying to measure the sediment load into a particular Virginia stream by the flow of the water. And the Attorney General of Virginia challenged that in a federal court over here in Alexandria, and prevailed that a TMDL based on flow is not appropriate. All right, and then another great way to learn a lot about, to really get into the current deep issues of the Clean Water Act and really get into the nuts and bolts of how the Act works is the ongoing issues on multiple fronts involving the regulation of coal and coal mining in this country, and its intersection with the Clean Water Act. The current administration, environmental groups, and the regulated community all each have their own very strong views on methods of mining of coal and the extraction of coal and the environmental regulation of coal, and there have been a number of recent cases under the Clean Water Act that are, especially for students, should be very, very interesting and very good to read to appreciate the battles going on in the scope of Clean Water Act authority. The first one, the 404C veto authority. I think Erin, when she was talking about 404 permits, talked about how the Corps of Engineers is the issuer of those permits, but EPA has a veto authority. EPA has rarely exercised that veto authority, I think just a handful of times in the past 40 years. Back in 2011, EPA invoked its 404 authority to veto a permit. However, the permit had been issued several years prior. The company already had its 404 permit as part of its coal mining operations in West Virginia, and argued that EPA could not veto a permit after it had been issued, that the scope of EPA's 404C authority had to happen sometime before the Corps made its final decision. And this goes into the issues in this case involve a detailed analysis, kind of the plain language of 404C. The district court sided with the mining company, and she looked at the Clean Water Act as a whole in conjunction with the language of 404, and said that the statute does not allow a post-permit veto. However, then obviously, as you can imagine, the government appealed that to the D.C. Circuit. And it was a very recent decision from just a few months ago. The D.C. Circuit reversed, looking at 404C the plain language of 404C, which contains the word whenever. And Judge Kavanaugh and others on the panel, Judge Henderson, I believe, wrote the opinion, looked at 404C in isolation and said that EPA had this authority to revoke a 404 permit even after it had been issued. As you can imagine, there was enormous amicus participation in that case because of the larger concerns of the regulated community with respect to certainty with permits. Once they are issued, the ability of EPA to invoke its 404C authority after a permit's issued implicates a number of regulatory certainty concerns that a number of amicus discussed as well. The mining company just filed a petition for rehearing en banc. They retained Paul Clement, the former Solicitor General, as part of that. So this is, I have no doubt that regardless of what the D.C. Circuit does on rehearing, that I see a cert petition in our future, I'm guessing. Now this I will not go because I don't want to run short on time for questions. So I will not. I'll leave these citations up for you to take them down. I won't spend an enormous amount of time on this litigation because it's also I could easily speak on this for 3 hours, and I think Chandra would have my head if I even tried to go more than 5 minutes on this case. But this goes beyond just one mining company, which is what the 404C litigation was about. This involves the 404 and 402 permitting processes for Appalachian coal mining. Again, I'm counsel in this case, I should disclose, and we have a D.C. Circuit brief as appellees due on Monday. So I'm living this case at the moment. But the bottom line is that in 2009, EPA and the Corps, but primarily EPA, amended the permitting processes for 404 permits and then began to issue a series of guidance documents that we contend impose new substantive standards and water quality standards for 402 permits. In 2010, both the regulated community, I represent National Mining Association, in addition, the states of Kentucky and West Virginia all filed suit against EPA challenging what are a series of memoranda and policy statements from EPA that work to amend the 404 and 402 permitting processes and standards. We received a series of decisions at the district court level upholding industries and the states of West Virginia and Kentucky's challenges to these EPA actions as contrary to the authority in the Clean Water Act, and also to the environmental law that regulates coal mining, known as SMCRA. That could be a whole other ELI course, right there. But the bottom line is that that the district court defined the relative roles of EPA and the Corps under Section 404, and all three of those cited decisions that are on the PowerPoint are now currently on appeal to the D.C. Circuit. And then also that all of these actions were taken without notice and comment rulemaking as well. But they are, in terms of the district court decisions, again, if you're looking to understand the intersection of 402 and 404 permitting, the district court decisions give a helpful background explanation on those provisions. And then finally, citizen suits is a very active area for coal mining. Just several weeks ago, a new lawsuit has been filed in Seattle in Washington Federal District Court alleging that coal that falls from rail cars while they are moving through the state of Washington and that coal dust that blows off of rail cars and eventually deposits into waterways, that those are regulated discharges under the Act and are not and require NPDES permits. And I'm not in a position to comment further on that case, but we'll see how it goes. It's a brand new piece of litigation with novel allegations involving what is a point source, what is a discharge, and what is regulated activity under the Act. Also, there's heavy citizen suit activity in Appalachia over coal mining activities there. They're looking, the citizen groups are looking to impose, as I said, numeric conductivity limits. We say, what conductivity, is that a pollutant? It's the ability of water to conduct electricity. It's usually meant to be a surrogate or a measure of solids in water. And there's a great deal of activity in scientific study going on the measure of conductivity and its impact on water quality and what is harmful level and what is not a harmful level. And in the absence of the federal government or the states adopting any kind of water quality standard for conductivity, the citizen groups are pushing for that in their citizen litigation. The state of West Virginia in legislation has rejected conductivity as a valid measure of water quality. And obviously the citizen groups there feel otherwise and are litigating accordingly. Also, selenium is another is a constituent that is also very much in the crosshairs with respect to coal mining and permitting, and what the appropriate selenium standard should be, and what it is, and what it should be, and how it's complied with, is also a matter right now of intensive litigation. And no shortage of suits and decisions to read on that point. But those are just an overview of some of the really the active and hot topics happening right now in the Clean Water Act, and I'll pass it back to Erin to see if there are questions.
So here's another picture of another favorite water body, the Columbia River, here in Astoria, Oregon, and you can see a container ship going up the Columbia. This is a very wide part of the Columbia, and so another example of interstate commerce on our traditionally navigable waters. We got another great question from one of our colleagues on the phone. And the question is, if a body of water is not classified as a water of the United States, are individual states allowed to regulate it? And this is a great question. Actually, ELI just did a report on this, which I think you can find on their website. And the answer is sometimes, and it varies. Some states actually have either state statutory or regulatory restrictions on whether or not they can regulate waters that are not within the scope of waters of the United States. Some of these restrictions say that the state can not be any more stringent than the federal government would be. Other states do have within their property laws or their environmental laws the ability to regulate more waters than would be classified as waters of the United States. But again, there's nationally a very wide-ranging set of rules and laws, and it's kind of hard to pick out a trend and why certain states do it some way and not.
And I think also that I think the prime example of that is groundwater. As Erin mentioned early on, groundwater, not a federal water, not federally regulated, not a water of the United States. So groundwater is exclusively within the province of the states should they choose to regulate it. Similarly with intrastate waters, but there are some states who have extensive definitions of what is a water of the state, and then that would go, and some of them do go to the Ben Grumble's definition of every puddle in a state is regulated. But important to note, but those are only regulated then under state law. So for example, you cannot bring a federal Clean Water Act citizen suit to enforce against violations of in a water body that is only a state-based water body. You have to look to the state law that governs that water body and any state enforcement provisions that are allowed. But you can't. There have been, there is precedent in terms of citizens that have tried to regulate groundwater discharges to a non-federal water under federal citizen suits, and those have not been successful.
Yeah.
Thanks. I was just going to ask about the TMDLs and if they are the main mechanism by which water quality is measured, and also then off of that, are all pollutants, do all pollutants have TMDLs, and are TMDLs consistent based on water geographic location or like by states, and do they keep it consistent if a water body spans more than one state?
Excellent questions. Okay, that was a three-part.
Yeah.
You write that down. Okay, I will try to repeat it, and I'll let you. So we have a multi-part question there on TMDLs. The last one involved in terms of interstate water bodies and in terms of how that's treated. are TMDLs the primary method of measuring water quality standards? And I don't remember the second
Do
one.
all pollutants have TMDLs?
Oh, do all pollutants have TMDLs?
Yeah.
Okay, very good. Do you want to?
Sure. So for the geographic scope of TMDLs can vary widely. It can be, as Kirsten talked about, as big as a watershed like the Chesapeake Bay, or it could be a particular reach or portion of a river or stream that is impaired for particular pollutants. And so you can have a portion of the Boise River in Idaho impaired for phosphorus, and then another portion impaired for nitrogen and phosphorus, depending on what sorts of discharges and runoff they're getting, contributing to those loads. And then there are also TMDLs for upstream reaches of a river that then contribute into another river that has a TMDL for other pollutants. And so it does get very complex very quickly. Do all pollutants have TMDLs? It really depends on the water body and what the water body is used for, and whether or not that water body is impaired for those uses. And so there are common pollutants. There are common pollutants that often show up in TMDLs, but certainly not all of them.
Yeah, I think that's pretty. Yeah, and I would note that it's also states have been. There's been delay, in issuing TMDLs. Not all. I mean, Erin put up a very large map, of impaired waters at the beginning of the presentation, and not all impaired waters in the United States yet have TMDLs. As you can imagine, they take time and science and deliberation and public participation to develop. There are many TMDLs in the United States, and I think Erin is right that most of them pretty much are on intrastate segments of waterways, and there have been, I think there's been one other interstate federal TMDL before the Chesapeake Bay TMDL. I think maybe in the western U.S., maybe in Washington, Oregon area is, I think so, but I can't. I'm not remembering off the top of my head, but in general, it has been there have been very few federally issued TMDLs. Most are issued by the states and then subject to EPA review and approval. But Erin's exactly right that it depends on what the waterway is impaired for. What pollutants are subject or causing the impairment. That's what drives the creation of the load.
But permits also protect water quality when there's not a TMDL.
Yes.
By the we talked about water quality based effluent limitations.
Yes.
If a technology based effluent limitation isn't enough to get the effluent to a point where it's not going to cause an excursion of the water quality standard, then a permit writer will write in water quality based permit effluent limitations to protect that way. Yep.
Yep.
I also have a question about the load limits. I would assume that the daily load limit isn't dependent or determined by just looking at a day. I assume it's on a larger scale. And if so, I'm kind of curious if these limits account for large scale events that are out of the ordinary, like crazy floods or hurricanes, other things that are obviously going to affect what's going into the waterways. And if so, how they do that. And the second part of that question is, if you've determined the load limit, do you max that out, or is there a buffer that's left?
Okay, well, I'll take a crack at some of these. And okay, well, with respect to daily, it was interesting. The D.C. Circuit has recently answered that question on how daily means daily. That's what Congress put in the statute, because actually Washington D.C. attempted to do a monthly average TMDL for the Anacostia River, because the Anacostia River is impaired for so many things, and this was a number of years. This was at least maybe 6 or 7 years ago. And it was litigated that, I believe by environmental groups saying, no Washington, D.C. and EPA, you need to have a daily limit for the Anacostia River. And the D.C. Circuit looked at the statute and said, well, yes, it does need to be daily, and so it is measured in terms of daily loads. Now that said, that's then translated into permits, and so there really isn't so when you have a flood, when you have an act of God, for example, that overwhelms a water body, I mean, there isn't an enforcement mechanism for that, right? You can't, you can only, those loads get translated into people's permits, and so there's no EPA can't, I don't know who EPA in the state sue, right? When there's a huge flood, if your own discharge is still within limits, and also there can be terms and conditions within your permits that address most people have extraordinary event terms and conditions also in their individual permits as well to deal with that. In terms of maxing it out, another great cutting edge issue that I should have put on the slide, but it goes to trading. The concept of trading, which is actually currently the trading provisions of the Chesapeake Bay TMDL are actually currently being litigated here in federal court here in DC by environmental groups who say that trading is unlawful. But it works like this. Yeah, the Bay TMDL, right, kind of sets the load and then has allocated that load among all these sources. So what do you do if you want to open a new plant, or you want to build a new housing development, and therefore you need the new sewage treatment plant for the new people who are going to move in? How do you work that into the load that's already been set? Well, you ask a farmer to engage in some form of land conservation practices that's going to reduce his non-point source runoff off of his land, and then you calculate whatever's being saved off of his land that would have been in the non-point source part of the load allocation, and you give that to the POTW and say, here's you're going to get this traded from the farmer, and this is now your load, and now you can have the new source and build the plant. And so nutrient trading goes on. Pennsylvania has it. EPA has a wonderful website actually on trading, and it's mostly happening right now in nutrients, because that is those are nitrogen, phosphorus, and sediment are kind of ubiquitous constituents that are affected across so many different activities. But that's how the Chesapeake Bay TMDL is accounting for new sources without going past those ceilings. So
I think you had it all.
Yeah. Or anything?
Yeah.
Did that answer? Anything else from that?
I guess this is my question about. My question is, I guess, how do you determine the limits? And if you account for, because if you're determining the limits based on what the waterway can handle and remain at a certain quality level, do you then kind of account for those extraordinary events in the determination of the limits?
That's a good point. Okay, she was asking a more refined question on how the loads actually get calculated, and this is where we need an environmental consultant at the table, because this is where I will exceed my expertise, and one of the great EPA Office of Science people here. The folks who, there's intensive science that goes into the development of the load in terms of studying the water body, the sources of the water body, what is the water quality standard that's looking to be maintained or achieved. So of course, if you're impaired, you're looking to improve the water quality, which means you want to lower, the load. And so, but that is done, like I said, that is done through, intensive monitoring and scientific study and modeling, and obviously, yes, various events of, various weather events, I think, are put into those models. I know they certainly were put into the extensive Chesapeake Bay, very, very complicated models that went into the Chesapeake Bay TMDL, as you can imagine. But that's where the rubber meets the road. Very, very, very smart people, far smarter than me, build very sophisticated water models in terms of all the inputs from weather, right, from non-point sources, from point sources, all the variations. Water that runs over parking lots is different than water that runs over a field. I mean, all of those things are calculated and then determined. But
I was wondering if you could talk about some of this technology that's being used to, prevent and/or reduce the discharge.
Sure. So the question is a little bit of a discussion about the technology that's being used to reduce discharges. And one interesting aspect that you might want to look into more is the idea of green infrastructure. And where it's difficult to, Kirsten was just talking about runoff from parking lots and farms. There are new and interesting developments in ways to reduce that kind of runoff, whether it's having pervious surfaces, so instead of just the water hitting a paved parking lot, maybe the company includes a technology where the water can seep in slowly into the groundwater. There are innovations all around, even in DC, which I think has done a great job in including green infrastructure requirements. There are green roofs that instead of the water coming right off the roof, instead it goes into vegetation. In agriculture, one can install vegetated swales along streams in one's field, and so that, say, manure runoff doesn't there's almost like a stoppage before it gets right to the stream. It slows everything down. A lot of the green infrastructure technologies focus on that idea of slowing down the arrival of wastewater into waterways.
And in terms of, and I wasn't sure which particular industry you're talking about, for instance, because we can have a whole big discussion on how what technologies POTWs use. I mean, your Blue Plains, your wastewater treatment plants have, all the wastewater comes in, they have basic physical separation, trying to get the water out from all the solids and all of their muck that comes into a sewage plant, and then following a physical separation process, there's biological treatment where they inject various bacteria and bugs into the water to basically eat a lot of the nutrient pollution in a wastewater treatment plant, and then following biological treatment, then the water is then hit with a huge dash of chlorine, and then it's discharged. But in industrial plants, there's all kinds of treatment plants that are used and various treatment technologies. It really depends on the industry, and actually that's where the ELGs that EPA has developed at 40 CFR Part 400, based by industry, kind of outline the various technologies for each industry, but it varies. It varies by industry. In animal agriculture, large animal agriculture farms. They take the wastewater, from the barns. They're either in underground lagoons or above ground impoundments, and again go through the same kind of biological treatment that human wastewater treatment plants go through. But obviously, at industrial wastewater plants, there's all types of technology treatments to remove, to treat water for the toxics and other, the various types of industrial chemicals and whatnot that are used in a lot of our modern industrial processes. But they are, but they're very, and technology continues to improve and gets much more sophisticated in terms of how various waters can be treated. And but like I said, those are generally outlined both in the regulations and in folks' individual permits.
I may be a little confused on the regulation of non-point. If it's not regulated by the CWA per se, non-point source pollution, but if it's not, how do you deal with new development, et cetera, that may contribute to non-point source pollution that could affect the TDML for current users? And are there ways for, say, municipalities who may have to, be investing in new technology to decrease their discharges? Can they put mitigating measures into, say, a permit application to try and mitigate non-point source pollution in other places in order to successfully move along and lower costs that might be directly borne by the community to get a permit?
So the question went to the regulation of non-point sources and the imposition of TMDLs. And I will try to take a crack at this one. Well, you are right. Let's start with the premise that, yes, non-point sources are not regulated under the federal acts. But there are non-point source provisions in the Clean Water Act that basically direct that non-point sources are to be regulated by the state at the state level. And states are, and the Clean Water Act provides for grant money, for funds for the states to regulate non-point sources. And to me, this is why the implementation of a TMDL is so important to happen at the state level, because that is where the authority for regulation of non-point sources lies, and is up to the And we can do it with a concrete example of water body X. We have 5 point sources. We have our dispersed various non-point sources, and we have a load that everyone is currently meeting, and we want to have a new development come in. It should be then up, under the Clean Water Act, it's up to the local state regulator to decide how to rebalance the load and waste load allocations between the non-point and the point sources to accommodate the new development. That could happen through trading. That could happen through ratcheting, and this is obviously, as you can imagine, what municipalities are incredibly concerned about, that they are the ones who are going to take the first hit, because the point sources are the easiest ones to go after. Let's ratchet down the ones with the permits that have the numbers, and let's hit them first before we try to figure out a new allocation for the non-point sources. And so it's a legitimate concern. It's actually a very live policy question right now at the state regulatory level. And but that is how it's supposed to work. That the state looks at the inputs, right, to that water body, and figures out and makes the political and policy choices on how to still meet the load.
I was wondering if there's much of a live conversation right now about federal legislative reform for the CWA, and if any, what are the primary issues being discussed?
Let's see. So there are various amendments that come up at different times about limiting EPA and the Corps' ability to, for example, implement a Clean Water Act policy that would clarify waters of the United States. There are a lot of symposia around the 40th anniversary of the Clean Water Act talking about, when is the next, Clean Water Act's 40, does it need do we need to look at it again? The last time that it was truly amended was in 1987, so it's 26, those amendments are now 26. I don't think that, and again, this is Erin talking, not EPA talking, I don't see a broad-scale amendment to the Clean Water Act right now. I mean, there are so many competing political factors, whether it's coal or agriculture or real estate development, that have various interests in amending and then I think the one fundamental question is, do you strengthen the Clean Water Act, or do the regulatory authorities have too much power? But that discussion's ongoing, and that was, I think, a little hotter on the Hill a few years ago.
No, I agree with that. I think waters of the U.S. has been a topic on the Hill for a while. I wouldn't say I haven't heard anything about comprehensive legislative reform in a long time. It tends to be more surgical strike, issue-specific targets based on what's happening in the courts or what's happening at EPA at a given moment. So that's after Rapanos, there was a lot of activity toward legislative solution on waters of the U.S. to deal with the uncertainty created by the Supreme Court's decision and differing opinions between the Hill and EPA on how that definition should come out.
And the Farm Bill amendment yesterday.
Right. So, for instance, yesterday's example, perfect example of an issue-specific amendment to the Act. Addressing the issues raised in the Supreme Court Decker case. There are, to no surprise, the Appalachian, legislators from Appalachia have proposed bills to deal with both the Spruce 404C veto. There's been legislation proposed to further define, curtail, however you want to characterize it, EPA's authority under 404C. There's also been legislation proposed to deal with the permitting process issues that started in 2009 for the coal industry. So it's been very targeted approaches, and nothing has passed, which for those of us who are following Congress, that should be. Other than the Farm Bill amendment yesterday, which is why that's almost a small miracle that actually the Farm Bill passed the House yesterday. Oh no, I'm sorry. Various amendments have passed the House. It's supposed to go for a vote today.
We do have another question from our colleagues on the phone, and the question is: does the Clean Water Act regulate water withdrawals? So I think this could go. I have a couple thoughts on it, and So it doesn't regulate irrigation withdrawals or water rights that one might have under a prior appropriation scheme, for example, and because again, the Clean Water Act generally does not regulate water quantity. And return flows from irrigated agriculture are not additions of a pollutant from a point source. One thing that did come to mind was cooling water intake structures, and there could be conditions and permits, for example, for power plants that would define how much water the plant expects to take in during a day and how much it expects to send back out into the waterway. There may be heat limits. Remember that heat is a pollutant, and so there could be limits for that in a power plant's permit. And also there could be conditions on a power plant's permit to do with intake structures. And they might need to install particular technology to reduce entrainment and impingement of fish.
Right.
So that has to do with intake.
No, that's
I don't
right.
know if we got
but that springs from a specific section in the
Yeah.
Act. So absent 316B, which regulates the cooling water intake structures, I don't, you know, as you noted at the beginning, the Clean Water Act does not really deal with water quantity, how much water you take out of a water body. That's an issue of state water rights law, which mostly is dealt with. Mostly our friends west of Mississippi deal with that. It's not really much of an issue in the east.
All right. So thank you very much.